In this lesson, we will analyze a specimen legal opinion about EU Blocking Statute versus secondary sanctions. Let's see firstly the scenario. An EU-based bank with US operations is asked to terminate a contract with an Iranian entity following US secondary sanctions. The EU blocking regulation prohibits compliance with US extraterritorial measures. Specimen Legal Opinion 1. Introduction and purpose. This opinion is provided at the request of client, an EU-based financial institution with US operations, regarding the legal implications of terminating a contractual relationship with Iranian counterparty following the re-imposition of US secondary sanctions. In light of the EU Blocking Statute Regulation 2271/90, 6 EC, factual background: client is incorporated in EU member state, with subsidiaries in the US. Client maintains a correspondent banking relationship with Iranian counterparty, an entity listed on the OFAC SDN list, but not subject to EU sanctions. The relationship involves US dollar transactions and exposure to both US and EU regulatory regimes. Applicable legal frameworks: CS law, OFAC secondary sanctions, e.g., Iran Sanctions Act, California ATA. IFA prohibit dealings with SDNs and entities subject to the OFAC 50% rule. EU law, EU Blocking Statute Regulation 2271/96E, as amended 2018. Prohibits EU persons from complying with specified US extraterritorial sanctions, including those on Iran and Cuba. Article 5, Prohibition on compliance. Article 6, Right to recover damages. Article 9, Penalties for non-compliance. Key case law, ECJ Telekom Deutschland v. Bank Melli Iran 2021. EU companies cannot terminate contracts to comply with US sanctions unless they prove the decision was not motivated by such compliance. Analysis of conflicting obligations. US position. Failure to terminate the relationship may expose client to secondary sanctions, including SDN designation, exclusion from the US financial system, and substantial fines. EU position. Terminating the relationship solely to comply with US sanctions is prohibited. If challenged, client must prove the termination was for legitimate, non-sanctions related reasons. The burden of proof lies with client if there is prima facie evidence of sanctions-motivated termination. Conflict. Compliance with one regime entails violation of the other. No safe harbor exists. Let's go to terms number 5 for this specimen. Risk assessment terms. 5.1 Legal risks as US exposure. The relevant entity may face SDN designation, loss of access to the US financial system, and civil criminal penalties under US sanctions laws. EU exposure. Non-compliance with the EU blocking statute may result in civil liability, fines, and contract reinstatement orders as enforced by EU member state authorities. 5.2 Regulatory risks a US exposure. OFAC may initiate enforcement actions, impose penalties, and cause reputational harm to the relevant entity. EU exposure. EU national authorities may enforce penalties or litigation may arise from affected parties for breaches of the EU blocking statute. 5.3 Commercial risks a US exposure. The relevant entity may experience disruption of US dollar-denominated transactions and exclusion from US markets. EU exposure. Overcompliance with US sanctions may result in the loss of EU business opportunities, reputational damage, and strained counterparty relationships. 5.4 Conclusion. The relevant entity faces significant legal, regulatory, and commercial risks under both the US secondary sanctions and EU blocking statute, requiring robust compliance measures, risk mitigation strategies, and documented legal analysis to navigate conflicting obligations. End of Article 5.0. Studying risk assessment terms. Terms number 7 are disclaimers and limitations. This opinion is based on facts provided as of date. It does not constitute a guarantee of regulatory outcomes and is intended solely for the use of client. Terms number 8 are appendices. Sync copy of Regulation 2271/96 OFAC SDN list. Excerpt TN list. Excerpt Telekom Deutschland v. Bank Melli Iran judgment ownership charts and correspondence. Key practical points. Sovereignty of proof. After the ECJ's 2021 ruling, the company must prove any contract termination was not sanctions-motivated fine. Proportionality. National courts must weigh the proportionality of reinstating contracts. No safe harbor. There is no clear legal path that avoids liability under both regimes.